This is an interview with Professor Donald Langevoort for the SEC Historical Society. Professor Langevoort is the Thomas Aquinas Reynolds Professor of Law at Georgetown Law Center. I'm Donna Nagy, and we're at Georgetown Law in Washington, D.C. on February 11th, 2020. Thank you so much, Don, for taking the time to talk to us.
Certainly.
These oral history interviews often start off with a general background question about where you grew up and attended college and law school. So it would be great if you could share that information with us at the outset.
Sure. I grew up in New Jersey, just outside New York City, so I was a New York kind of kid. Went off to college at the University of Virginia and Harvard Law School, and came to Washington for the first of two times in my career to work at Wilmer, what was then Wilmer, Cutler, and Pickering. Went to the SEC in 1978.
Okay, well, so why did you decide to attend law school? So you had your 4 years in Charlottesville, Virginia, and attended UVA.
Oh, it was well before that.
Okay.
And there were no lawyers in my family.
Mm-hmm.
So there was nothing in my background to indicate this. But I still have a notebook from my sophomore year in high school where I listed the law school, not the colleges, the law schools I was planning on applying to and what I'd most want to get into. So for some reason,
Was Harvard there at the...
Harvard was there, yes.
Excellent, good.
So I don't know what provoked me, except intellectually, I thought law was fascinating, and that stuck with me. That's why I'm a law professor.
So without lawyers in your family, law being fascinating, where did that fascinating come from? Was it books? Was it television? Was it...
Probably all of the
Okay.
above. I went to a really good high school,
Mm-hmm.
and there were lots of opportunities to delve into subjects and do debates and things like that. So I must have stumbled over the law enough times to say, I may be good at this.
Uh-huh.
My mind thinks like a lawyer, and I find it really interesting. So.
You mentioned debate. Did your high school have a formal debate team that
It did,
competed?
but I wasn't on it.
I see.
I
Okay.
played basketball, so did not have time to
Right.
to do that.
You have to choose your activities. That's right. So, well, that's fascinating. So you've been a law professor yourself now for nearly 40 years.
Correct.
Looking back on your law school days, at Harvard, what classes or professors had the most lasting impact?
That's another transition story because
Sure.
I was a religious studies major in college,
Okay.
which you wouldn't think would be a jumping off point to go to law school.
Ah.
But turned out to be the perfect jumping off point because I was studying the sociology of religion, the psychology of religion, belief structures and things like that all turn out relate clearly to how legal regimes develop in a society. So I was not sure at all what I wanted to do with a law degree. And I took corporations from Louis Loss, who was not the greatest teacher in the world, but I found the subject fascinating.
Mm-hmm.
And didn't expect to make that transition from somebody who would have answered, well, constitutional law is going to be my favorite subject, to, gee, corporations, and then I ought to take some upper level courses. So what happened, and I had lots of great professors there, but I decided to take a seminar with Louis Loss because I had liked his class, and I had heard he was better in seminars than he was in a lecture class. And at the time, he was in the midst of the Federal Securities Code,
Okay.
a project that we're going to talk
We're
about,
going to talk
I'm
more
sure.
about that too. Yes.
And the price of getting in the seminar was you were going to take a topic in the Federal Securities Code that Loss needed research help on. And so this was a way of getting 20 research assistants
No
to
better.
be focusing on. I randomly picked the preemption of state tender offer regulation
Okay.
and the structure of the Williams Act. Wrote my paper. After graduation, my paper got published in the Cornell Law Review. So it was Louis Loss guiding me to this subject.
That's wonderful. So time frame wise, this would have been probably 1975-ish.
I graduated in '76.
Okay.
So yeah, the course was '75.
And the course name again? Was? Do you remember?
Probably seminar.
Topics in securities
Exactly.
regulation. Yeah.
It might even have mentioned the code.
Okay.
Loss was so immersed in the work on the code that it wouldn't surprise me that it was that up front.
Right. Well,
and I certainly understood that this is what I was getting into and this is what I wanted to get into.
So why don't I know that at the Securities and Exchange Commission in 1978 you helped work on the code
Right.
project. Why don't we talk about the code right now?
Okay.
Particularly in the eyes of a law student who was being involved in this project at its earliest, well, not at its earliest stage, this was a very long project, at its middle stage.
Yeah, and its most important stage.
Okay.
Because the code project brought the great eminences of securities regulation circa 1950s, 60s, and 70s. Under the guidance of Louis Loss and his advisors, Milton Cohen being the most important of the advisors, to do the rather shocking thing of saying we could sit down and rewrite all the securities laws and get it better. It took a little arrogance, and this group that was working on the code was not lacking in arrogance. And so to watch it get molded, and then comes the mid-'70s, where it's polishing stage. You know, most of the drafting had been done early '70s.
Right. So when we say, or when you say, shocking thing of rewriting the federal securities laws, we're basically then talking about taking 4 separate congressional statutes and all of their amendments and combining them.
Right, and I think it was more than 4, because you had things like
6,
SIPC.
that's true.
Yeah.
The Public Utility Holding Company Act and the Trust Indenture.
Right.
Yes, okay.
And the theory was to take New Deal style regulation, which was very much built on the give an administrative agency the discretion. So general terms, principles, rather than, there were plenty of rules, but it was very classic New Deal. And Loss didn't like that. Loss and his advisors had said, you need more formalization to the lawmaking process. So as a classical response to the romanticism of the New Deal era, that's what was driving it.
And I would imagine significant repetition in the Exchange Act of 1934, the Securities Act of 1933, the Investment Company Act of 1940, Advisors Act. Each has a jurisdictional provision, each has SEC powers, each has an anti-fraud provision, and the idea of the code is to consolidate in part?
Consolidate, but as with all work of the American Law Institute, and the code was an ALI project, to make it better when it needs to be made better. So Loss resisted the idea that this was simply a codification, that you were taking what was already known and putting it in statutory language. The code was very innovative, substantively, and that's what they were most proud of. that's the arrogance I was talking about before. We can do it better.
Yes.
We don't just need to put this in statutory form.
So what an incredibly fascinating and unique opportunity for you and the other 19 law students in this seminar to choose a topic that then finds its way. And in 1975 to 76, the hope is that Congress is going to pick up the code and enact it into positive law. And
yes,
so,
and it was really, surprisingly in hindsight, simply assumed that Congress would do this.
So you really are writing law at that point as a second or third year student at Harvard Law School. You and the 19 other people then.
By 1975, there were drafts of everything.
Right.
So this was, do we have to change it? I was asked to write on the preemption of state tender offer regulation, which was a hot topic in the late 70s.
Yes.
So you had the Supreme Court deciding Edgar versus Might, later on the CTS case. So my job was to make sure that all of these rapidly happening developments were adequately dealt with in the code.
Right.
Hopefully via comments rather than changing statutory language, because that's, Loss had gotten agreement on the statutory language stuff.
Yes.
But if the comments needed to be rewritten, that was sort of what we were providing the information for.
Yes. What an ambitious project of Louis Loss and his advisors, and how creative to involve law students in that. So. Two law professors can talk about law school all day, but I better get off. But I will ask two more questions about, were there any other students in that seminar that went into academic careers?
Not that I recall.
Knowledge?
In fact, I couldn't tell you who else was in that seminar.
That's it. And then other than Professor Louis Loss, were there other corporate or securities professors at Harvard at the time that had a memorable role in your development?
Professionally, lots of other professors had big impacts on how I teach as a law professor, even though they had nothing to do with corporate securities law. Vic Brudney was on the faculty, and he was the one all the people most interested in corporate and securities laws wanted to take, because he was an innovator. He was one of the first. He was pro-regulation but steeped in economic theory and doing remarkable work in the first battles over law and economics and their place in securities regulation. So he was wonderful to just sit and listen to.
Incredible. So you leave Harvard Law School then in 1976, and your first job after graduation is a law firm associate at Wilmer, Cutler.
Wilmer, Cutler, and Pickering.
So can you share some specifics about that experience? Why there? Why Washington, D.C.? What type of work?
Yeah, all of the above are really interesting. I expected my summer associate job after second year in law school was at Cravath in New York. And I expected at that time, since I liked corporations and liked this stuff, well, what else would you do except go to New York City and become a deal lawyer? And I was all set, got an offer from Cravath, was about to accept it, and realized I didn't like transactional work very much. I was more interested in the intellectual side of all of this. And it was getting late. Everybody had their job offers, and I had my job offers, but it was, and somewhat funny story, Cravath had a relationship with Wilmer, Cutler, and Pickering for referring work that was more appropriately done in New York as opposed to Washington as opposed to New York. And everybody from Wilmer would be invited up to the Cravath party each summer. So I now heard of Wilmer, Cutler, and Pickering, and these people seemed nice, and it was very much Washington rather than New York City, and they were talking about doing projects that were not just deal documents. So very lazily, I said, okay, I'll go to Washington, and I know one firm there, so there it is. That's how I ended up.
For securities litigation, for securities enforcement in the 70s, what a wonderful place.
What a wonderful place, but there were only 35 lawyers there at the time. And very much an attitude that you do not specialize.
Okay.
There were no departments. So I was brought in my first week there, I was told, you're going to work on a First Amendment brief before the Supreme Court. CBS was one of Wilmer's. So you're going to do First Amendment.
Yeah.
And then there are a couple people, Art Matthews and Mike Klein, who they need some help. And then there's this international arbitration. I was just assigned to all of that. And the more partners you worked with, the better. No coherence whatsoever. It was just, you'd be good at this and you'd learn something. But it turned out that I became good friends with Art and Mike and asked for as many securities projects as I could while I was working on arbitrations and First Amendment and other things like that.
So Art Matthews would have been developing an SEC enforcement type practice at Wilmer. He had left the commission at that point.
He had left a few years earlier. Was building what he wanted to make the elite securities practice in Washington. So Manny Cohen, who had been the chairman of the SEC, came to Wilmer as of counsel. Al Summer, one of the great commissioners of all times, was brought in. So they were growing the securities practice, but it was all Art and Mike. And in the end, those were the survivors who built what we know today as one of the best securities practices anywhere.
Absolutely. With legions of SEC alums,
yes,
particularly from enforcement.
Yes.
Excellent. So then you're there at Wilmer for about 2 years.
2 years.
And what prompts your decision to apply for a position at the commission?
By that time, just like I learned I didn't want to be a transactional lawyer, at Wilmer, I was not sure I wanted to be a practicing lawyer.
Okay.
And my academic instincts had gotten me to say,
I see a funneling here of sorts.
Right.
Okay.
And so at that time, I decided I was going to go in the teaching market. I had no idea what that meant, but I was going to go into the teaching market. And I read an advertisement in the Legal Times of Washington, SEC Office of General Counsel, looking for staff attorney, Federal Securities Code project. And I said, okay, I want to be an academic. Here's somebody trying to rewrite the entirety of the securities laws. Here's somebody needing help with the Federal Securities Code. I know Louis Loss.
Right.
We've been in contact ever since my graduation. So this is, too coincidental not to pursue. So I said, and I told both Mike and Art Matthews I was going to do this, and they were thrilled.
I'm sure.
Their view is spend time at the SEC sometime in your career, you owe it. So that was fine with them if I wanted to go there, which meant my references were Louis Loss, Art Matthews, Mike Klein. For a staff position in the Office of General Counsel, that's a pretty good lineup.
It sure is. It sure is. And you went into the interview knowing what the Federal Securities Code
knowing
was.
what it was, in fact,
which probably
knowing more
put
than
you
some
and
of
knowing,
them.
correct. Very interesting how that came full circle.
Right. And it turns out, and I didn't know this, that Ralph Ferrara, who was the General Counsel at the time, had taken what I later learned to be the controversial step of building a policy planning unit in the Office of General Counsel. The operating divisions assumed policy planning was their assignment based on the specialty divisions. Why was the General Counsel Office doing this other than to grab a little power and authority? So it turns out Bob Posen, who later on went on to a extraordinary career at Fidelity and Mass Mutual, was the deputy heading up. So he was the one I interviewed with. He was a law professor at Georgetown and then NYU before going to the SEC for a little while. So we hit it off wonderfully.
Right.
We were kindred spirits. So yeah, it was very clear the job was mine. And I said, what a nice thing to do for a couple of years. In no sense was I cutting back on my desire to be a law professor. But for 2 years, this would be a good project.
Excellent. So I want to hear more about the policy planning
Yes.
unit of Ralph Ferrara at the Commission. Before that, though, to sort of contextualize this again, so the American Law Institute adopts the Federal Securities Code in May 1978.
Correct.
And so you're coming on then as someone to work on the next phase of this
Right.
project. So explain
Sure.
what that work is.
Yes. I later learned the motivation. I don't think we ever discussed this in my interview with Bob. Loss and his advisors had taken the key staff members in Congress and made them consultants or observers to the code project, all with a view that they would know the code so well they would just walk to Bill Proxmire on the Senate side, Harrison Williams on the Senate side, John Dingell on the House side, and say, we've been watching this for a decade now. It's brilliant. Adopt it. Of course, Washington doesn't work that way. And basically, Dingell and Proxmire, who were the two key members of Congress on securities-related matters circa 1978, said, this project isn't going to go forward as a legislative proposal. You can imagine jaws dropping unless the SEC endorses it formally. And the SEC had not been, for good reasons, had not been involved in this project. This was purely private. And so Harold Williams, who was the chairman of the SEC at the time, agreed, under prodding from Dingell and Proxmire, to take whatever time was necessary for the commission staff to learn the code and decide whether to endorse it. And estimated that was going to take a couple of years. Loss was furious. He was not expecting this twist.
He hadn't banked on a holding period.
But Harold Williams gave the General Counsel's office the responsibility for coordinating thorough staff review of the entire code. So it turns out, was hired to be the staff person
the quarterback,
who would coordinate.
Essentially.
Well, that's inflating its importance. Water boy might be the opposite end of it. But I was the one to make sure that there was a person in every division who would spend time learning, and I was there to learn it and answer questions for them. And then ultimately, the staff views would be consolidated under the direction of our group in the General Counsel's office.
So you were special counsel.
Ultimately promoted special counsel, but as the person to do this. And it turns out, and this was nice happenstance, Louis Loss very much wanted to, and his key advisors very much wanted to be involved in this staff, in the commission learning process. So there was a working group set up of code advisors, and I was the coordinating person between the code advisors and the staff.
So
that was really fun
and you
to
were
watch.
able to now work with
Milton
your
Cohen,
mentor and
yes,
Professor Loss
right,
again.
absolutely.
So how wonderful for that to come full circle.
Yeah.
So the SEC eventually does endorse the Federal Securities Code in that way, and then it is now destined to the hill.
Well, yes and no.
Yes and no, okay.
In the sense that as the 2 years transpired, not surprisingly, people at the SEC found lots not to like in the code. And our job at General Counsel's office was to see if the advisors would rewrite to address these concerns. And the answer was sometimes yes, most of the time yes.
Okay.
Especially if it were technical kinds of things. You know, the staff really knows its stuff and made some good catches. But on big issues, occasionally the code drafters would come back and say, wait a minute, this is the heart of the code. We can't change this. And the SEC said, but if you want our support, you got to change it. And what happened in the end was the commission voted unanimously to adopt the code with a schedule of disagreements that each side agreed Congress would have to resolve.
Okay.
Because there was no way of coming to consensus. So I think there were 30 or 40 scheduled items. Yeah.
So someone could have gone over to the Hill and continued the work on the resolution of the disagreements.
Absolutely.
Okay.
And, you know, it turns out, I think this would have been okay with the members of Congress who in the 70s were in charge of securities legislation. In the end, what did in the code, because it never did get started, even though the SEC, subject to the schedule,
Right.
Was a political shift. And by this time, you know, the gray eminences of securities laws were graying considerably. And they had made sure they controlled this process. So now younger people were coming up in the world of securities and weren't just going to say, well, because Milton Kroll and Louis Loss said that, then that's the way the law ought to be. There was now a more conservative movement in the Supreme Court.
Right, right.
And whereas it's probably true that in 1973, 74, 75, when the code was being dropped, it was delivering some good things to the business community. Now the Supreme Court in Hochfelder, in Santa Fe, was delivering some goodies as well, and they weren't reflected in the code.
Right.
In fact, in many ways, the code went back to securities law, Second Circuit, 1960s.
Yeah, and
A very romantic process of reading purpose into text.
the code did not
So,
reflect
the
the
code
series
didn't-
of retrenchment that the
Right.
Supreme Court began to implement.
So
in
we
the
had the
late 70s.
Reagan election in 1980. Yeah, that didn't happen until after everything I'm describing
Right.
had occurred. But you know, politics are changing. The view of what regulation is had moved on from the 60s, early 70s sense of if it's securities regulation, it must be good.
Right.
And if it's in the hands of Louis Loss and Milton Cohen, it must be better.
And
Yeah.
now we have skeptics on the Hill.
Skeptics, turnover. Harrison Williams is indicted. You know, you lose some of the people who were involved as observers. So they're new people, and to them, the idea of sitting down and rewriting all of the federal securities laws wasn't appetizing.
Yeah. Yeah.
And in the end, the code goes nowhere on the Hill. Now, Louis Loss, to his dying day, wants everybody to point out the many ways in which the code did have an impact. And it's true, in the 80s in particular, on many rulemaking projects.
So so if you can provide one example.
So integrated disclosure and shelf registration
Okay.
were taken from the code. Insider trading law came to reflect some of the ideas that were in the code. Many places the code got cited, but now we sort of have lost that history. So the influence was there, but it was never what Louis lost dreamed of,
Yeah, yeah.
which is the true codification.
We have lost much of the
Yeah,
history, which is why opportunities like this to rewind and,
Yes.
memorialize is so important. So then time-wise, here we're in 1979, 1980, where the realization that this was not going on the hill.
Yeah.
So you have a portfolio now
Right.
that needs other things.
So at that
the
point,
Securities and Exchange
you know,
Commission.
it was a why am I here? But this had been happening slowly enough that Ralph Ferrara and Bob Posen, you know, knew that my work had been done on the code,
Okay.
so put me to work elsewhere.
Okay. So let's talk. Was some of that on this policy planning unit?
Oh
and
yeah,
involved? Okay.
I was a dedicated person in
Okay.
policy planning, which was distinct from the litigation side.
Okay.
The larger portion of General Counsel was still the appellate work and the litigation on behalf of the commission, sue or be sued, the many things that a general counsel of an agency have to do. That was all elsewhere. Policy planning was this controversial rump group that would watch everything else that's going on and write memos to the commission if we didn't like or had something to disagree with. Naturally enough, what I had been spending most of my time on the code, I was becoming quite familiar with the thinking inside the agency, and thus insider trading, which was one of the hot button scheduled issues on which there could not be agreement. In order to get as close, we had been spending lots of time talking to all the divisions about, well, what would an insider trading statute look like? And I was the one with the file on that.
Okay.
Meanwhile, and this is nicely archived in the Historical Society materials, Dick Rowe, who had been the head of corporation finance, decided to move forward with a tender offer insider trading rule, because the SEC has rulemaking authority under the Williams Act that it didn't have on other subjects. And let me go back a little bit. In the code, Loss didn't want and was unable to get support for going any further than what today we regard as a classical theory of insider trading, which is if you're a true insider,
an officer, director,
or somebody with connections to officers and directors, you were not able to trade. So Texas Gulf Sulphur was good with them. But what was called market information trading at the time, there were famous law review articles on the subject, they just drew the line and said, we're not going to codify that. There was a catch-all provision at the very beginning of the anti-fraud section of the code that gave courts power to call things fraudulent. And Loss pointed out, you know, if someday somebody wants to make market-based insider trading illegal, use that. But that defied the idea of the code. You know, why have a code if you're then going to say, all that's interesting is left to the generic discretion of the court? So it was generally known that in market information, overwhelmingly, tender offer related market information was the most valuable, was the most sensitive.
And that's because the price of shares
goes up dramatically.
So a little bit of money can make a lot of money.
Exactly. So it was hypermaterial. And Dick Rowe, and he tells this in his oral history, decided to move forward with a tender offer insider trading rule. That immediately sets off battles. And obviously the General Counsel's team thought this was really interesting and frankly thought General Counsel's office ought to have a big say in what insider trading ought to look like. Enforcement wanted no part of any rule, any statute, or anything like that.
Right. So this project eventually becomes Rule 14E3.
Eventually does. And battles are going on issues like what we then called Chinese walls. What happens if one person in a financial services firm knows the information, another person in that firm executes a trade that turns out to be profitable? They don't necessarily know what each other knew, but the firm itself is both the trader and the knowledgeable person.
Right.
So that was a big issue that the commission was worrying about generally. It turned out that this was a project going nowhere as long as the divisions were at each other's throats.
Mm-hmm.
And that's what essentially was happening. So I got thrown into that one because they were at each other's throats for exactly the same reason that precluded agreement on the code's insider trading.
So typically one would imagine the Division of Enforcement at the Securities and Exchange Commission looking for a very broad anti-fraud provision that would capture much insider trading in the context of tender offers, because, as you said, that's the authority that gave the commission the power to adopt the rule. It had to relate to a tender offer. It was under the Williams Act.
Right, and Stanley Sporkin, who was director of the Division of Enforcement at the time, was very much committed to let me have 10b-5 and I can deliver good results. Put it up for political haggling, as the code was going to do, or as the Division of Corporation Finance wanted to do, was necessarily going to tie his hands. And he was strongly opposed to anything that might tie his hands. Now, in retrospect, we now know the Supreme Court made such a right turn.
Right, and we'll talk about the right turn.
That Stanley should have seen that coming and didn't.
Yeah.
He was wedded in the capital gains, the cases of the 60s and early 70s, and that's what gave him such confidence that you didn't want anything more than the generic statements you find in Section 10b and Rule 10b-5.
So you mentioned the Texas Gulf Sulphur Second Circuit decision, which was 1968. En banc decision, where the Second Circuit resoundingly not only sustains the liability of the officers and directors and employee in one of the defendants in that case. They're all traditional insiders, as you point out, but there's certainly language in the Second Circuit case that talks broadly about equal access to information and the justifiable expectation of the investing public. And that, no doubt, was some of what motivated Stanley Sporkin into believing that the language that the Second Circuit puts forth in the opinion is broad enough to cover not only the tender offer outsider situation, but the proverbial two people in an elevator who overhear type situation, where just any information lucrative is being discussed. The overhearer would be prohibited from trading under the broadest view of an equal access.
And here you can see the dots starting to connect.
Yes. Because
1968 was the beginning of the Code Project. And David Reuter, who then was a young, relatively young law professor, but very much up and coming and fairly conservative, wrote a law review article when Texas Gulf Sulphur came out, saying all that stuff about equal access is dicta that the court didn't really mean. And when you read the case as a whole, rather than just those sentences, you see a very different, more conservative posture.
Yes.
Reuter becomes the point person for insider trading on the Code Project. So when I said before that the Code circumscribes insider trading to the classical fiduciary type approach. That was a very deliberate decision. And loss was committed to it. That's why we never got anything further. So, meanwhile, inside the agency, Stan Sporkin, Ted Sondy, Ted Levine, his key lieutenants, all are seeing the opportunities in a broad 10b-5 approach. They are pushing cases forward that test the limits. And so you can see why they're looking at the Code Project as, in a way, an attack on the administrative discretion that they feel was appropriate.
So that's a great entree into talking about the Supreme Court's decision in 1980 in Chiarello versus United States. So as you know, this spring is the 40th anniversary of the Supreme Court's landmark decision. The SEC Historical Society and the IU Maurer School of Law, where I teach, and the NYU Pollock Center for Law and Business will be co-sponsoring a program that brings together many of the distinguished lawyers who were involved in that case. I'm happy to say that you are one of those distinguished lawyers, at least in terms of the aftermath of that case, and we'll talk about this. So I'm going to use some of our time together to take a deep dive into Chiarello history. So I'm guessing that over the course of your career as a law professor, you've taught the Supreme Court's Chiarello decision at least 50 times, maybe double that, maybe as many, depending on whether you teach it in corporations and securities regulation. So can you please recount its basic facts? And
Sure. And the important thing to remember as a preface is this is United States versus Chiarello. This is a criminal prosecution. Thus not in the hands of the SEC.
Yes.
So that's going to make this an interesting story in terms of political and jurisprudential power.
The SEC did have a
yes.
the
SEC actually
brought a civil.
It cracked the case. Ultimately, so what we have, Vincent Chiarello, or Chiarello, I believe, is the actual pronunciation of the name, but his name has been changed ever since. Was a printer, a typesetter essentially, at a financial printer in New York City. And under the Williams Act, anyone launching a tender offer has to, on day one, have available a disclosure document. Back then they were not electronic, a printed disclosure document to satisfy the bidder disclosure obligations under Section 14D. And he was able to see what was being said in type, and there were codes, but not very sophisticated ones, for the names, but he was able to decode and made some money. Not all that much money, but for a printer, I'm sure it was considerable, by buying stock in the companies named as target in the Schedule 14D ones. That he was caught. There were actually quite a number of financial printer cases going on at the time. Division of Enforcement brings an action. He quickly settles, essentially for disgorgement, and I believe an injunction.
Yes. So this would have been 1977.
And that's how most insider trading cases were then and still are resolved by settlement, not litigation. And then, because by this time the press, the media were picking up on insider trading as a great storyline, and the money to be made in tender offers and takeovers as a great storyline, the U.S. Attorney's Office decides no justice had not yet been done with respect to Mr. Chiarello, and they indict.
So the SEC's complaint and settlement was filed in the Southern District of New York in May 1977, and then the U.S. Attorney's Office begins its own investigation at some point thereafter. Chiarello is brought to trial in the spring of 1978, which is just around the time you're joining the commission. Do you recall when you first heard about the Chiarello case? Was it at that point during the 1978 trial, or was it later?
I am sure, first of all, I was on policy planning
Right.
at this time.
Right.
This issue, the coordination with the Solicitor General's office, which would be handling this case on behalf of the United States, was on the other side of the wall inside General Counsel's office and in the hands of Jake Stillman, Paul Gonson, and his team. So I am sure I first heard about it when the Code Project turned to the disagreements about insider trading, because so many Supreme Court decisions were changing the law of Rule 10b-5 that had to be reflected in what the code was doing, and the Chiarello case was clearly going to be a big one in addressing market information and addressing all those issues that the code wanted to stay away from, but now litigation reality was pushing them in the direction of.
Right, because we have so Chiarello is convicted. The Second Circuit affirms on a slight
in a very interesting opinion.
Okay,
that
why don't you say a few words
most
about that?
Most people have a recollection that the Second Circuit's Chiarello decision was simply an extension of the market egalitarian story that Texas Gulf Sulphur had told a decade earlier. In fact, the Second Circuit's Chiarello decision both disclaims that is true and quotes all that language, making it very confusing what they were saying. But a fair reading was that their decision was much closer to the SEC's original Katie Roberts decision than it was to Texas Gulf Sulphur. And that idea was actually a very comforting one for the SEC. Katie Roberts was its vision of what insider trading should look like. Texas Gulf Sulphur was the Second Circuit's, and the dicta there wasn't dicta the SEC was really pushing. It was something else. So I think a fair reading of the Second Circuit's opinion, which was very murky, is if you have a status that situates you close to sensitive market moving information, that special access creates a duty to abstain or disclose, to not trade on the basis of that information. Expansive enough to reach Chiarello, and Chiarello was working for the bidder, trading in the target company stock, but he certainly had a special status because law firms, printers, accountants, and others provide the lifeblood of day-to-day securities activity. And in the eyes of Judge Kaufman, that was enough to create a duty. So it tries to dance through this question of where do duties come from without giving a big hug to market egalitarianism.
Yeah, fascinating. So reading the Second Circuit's decision and then reading the government's brief, which was the Solicitor General's brief after the Supreme Court granted cert, so the merit brief.
Right.
It seems there was a substantial change in litigation strategy. The justification of the finding of fraud, the jury's finding the Second Circuit's affirmation of that shifted.
Right.
Can you tell us what you remember
Sure,
at the time of that?
and this is when I started hearing noises from the litigation side, Paul Gonson, Jake Stillman, and others, because they were, as a matter of standard Solicitor General policy, invited in as the expert agency. So people from the SEC, even though this was a criminal case, were going to have a role. But then they discovered that the team doing this at the Solicitor General's office, turns out to be a very famous team. Frank Easterbrook was leading it until just before the filing of the briefs. Other really famous people in retrospect were handling this, and they wanted no part of Texas Gulf Sulphur, Katie Roberts, or anything else. They wanted to make insider trading about the protection of property rights.
Mm-hmm.
That only when there is a misappropriation of the inside information, something akin, and I never realized this at the time, but today we see echoes of this repeatedly, something akin to embezzlement.
Mm-hmm.
Is it appropriate to bring in a prohibition against trading while in possession of that kind of information? That's not where the SEC wanted to go. This was becoming of concern in the building, that this 10b-5 duty and one of the core precepts, the prohibition on insider trading, was going to be taken in a very different direction. But that's the SG's brief.
Right. And so Frank Easterbrook, now Judge Easterbrook,
Right.
Was then Deputy Solicitor General in its waning. So
Right.
when cert was granted,
Yes.
he was already gone.
Right. So he transitions
Mm-hmm.
out, and he tells this in his oral history. He was there when the discussion started
Yes.
about the right way to handle this.
Right.
So his legacy is in the brief, even though his name is not on the brief.
Right.
So they pitch insider trading as a totally different story. And famously, the Supreme Court doesn't bite, not substantively, but because when you look back at the indictment and the way the criminal trial was handled, it really wasn't based on this theory,
Mm-hmm.
and so not properly charged became the Supreme Court's way of avoiding the misappropriation approach. We then know that the Supreme Court gives us a fiduciary-based approach to insider trading, with many cites to Katie Roberts. So in a sense, Chiarello, as the Supreme Court gives it to us, led some people at the Commission to breathe a sigh of relief. Katie Roberts and Commissioner Dick Smith's concurring opinion in the investors management case, some classic SEC get some good press.
Mm-hmm.
At the same time, the Supreme Court draws the line at fiduciary duty, thus cutting off, arguably, the ability to go after the Vincent Chiarellas and the others in the world of corporate takeovers, other places where it's market information rather than true inside information that's
Right.
at issue.
So time-wise, it's March 1980. The Supreme Court issues its decision, reverses Chiarello's conviction, as you said, for the reasons that you said. The majority, Justice Powell writes the opinion, chooses not to address the misappropriation theory, but actually leaves it open
Yes.
for cases subsequent to
Right.
potentially
And
raise
as
those
you well
issues.
know, there is both a concurring opinion by Justice Stevens and a dissenting opinion by Chief Justice Berger, who say, Stevens says, I agree, this wasn't properly charged, but I like that misappropriation theory if it's about fraud on the source of the information, about fraud in the entrustment of the information. Berger says, I think this was properly charged, and I think there's a duty to disclose that arises from misappropriation. Those ideas, survived the opinion because of the majorities saying, hey, just wasn't charged. This is for next time.
So the government's brief and the concurring or dissenting opinion together essentially raise two misappropriation theories. One is a fraud on the source. Chiarello, had it been charged to the jury, defrauded the printer, Pandit Press, and the investment banks. But Chiarello also defrauded the individuals on the other side of the transaction, the tender offer targets, because his theft of the information triggered a disclosure duty.
Right.
That's
Right.
So can you take us through the SEC's response then to the Chiarello decision as you sort of look back and remember it?
Sure, and that's where I become involved that day, literally, because
Okay.
I had plenty of insider trading responsibility before then because of the Code Project, but not major, because this was all being litigated and in the very good hands of Paul Gonson, Jake Stillman, and a remarkable litigation team. So they were on it. They didn't need me. But now you have the two consequences I just described. Some good dicta and good citations on what would turn out to be the classical theory of insider trading, when you could find a fiduciary nexus. But then that hard line, seemingly, about misappropriation, unless you could take up the invitation of Justice Stevens and Chief Justice Berger to bring misappropriation, to bring property rights in all of this. Now, remember, I said before, as the Chiarello case was going on, Dick Rowe in corporation finance was already pushing a rule that enforcement wanted nothing to do with. When Chiarello's decided, all of a sudden enforcement's position, which is 10b-5, is open enough for us to take any form of abusive insider trading and run with it, gets shut down. Ralph Ferrara, I think quite rightly, says we've got to act fast because now the whole tender offer world of insider trading is in question. So what do we do? And essentially, two decisions were made in the General Counsel's office, and I got both of these assignments. So I'm now over the wall and doing insider trading as a litigation matter, not just policy planning. One is to step in, for the SEC to step in with a rule that would essentially answer all the open questions left in Chiarello. So the rule, which was nicknamed 10bx, restated the classical theory pretty much as Chiarello had it, and then went on to say, and there are two more parts of Rule 10bx, fraud on the source and misappropriation as the basis for a duty to disclose. So a three-part 10bx rule that, if adopted, would now be the SEC's statement. Somewhat responding to an offhanded remark in the Chiarello case that Powell says, it's unfortunate we have to do any of this. Agencies should state the law. Well, Ralph said, that's what he's asking for. Other people in the agency said, you can't overturn a Supreme Court decision this quickly. It's not going to look good. Yes, you want this, but let's slow down. And so Court Fin argues, let's just handle the tender offer problem instead of going this far. Enforcement is still not sure what to do, but they see the writing on the wall that some of their discretion has been taken away. In the end, and this is May of 1980, the commission tells the squabbling divisions, let's prioritize 14E3.
Okay.
And prioritizing essentially meant that 10bx
Right.
Gets put in a file cabinet somewhere, never ever to see the light of day.
So Rule 10b5 or 10bx was proposed to the commission as a
Yes,
rule to adopt.
by the General Counsel's office. Immediately, Corp Fin proposed a counter rule and got investment management to join with them and market reg to join with them. And then enforcement wrote its own rule, which you can imagine was extremely flexible. So this is what was dumped on the commission in that meeting in early May. Literally 3 different Rule 10bx's, all put in motion by the General Counsel's office. And I remember the day vividly of watching the commission say, we're not going to umpire this battle. Get your act together, get a tender offer rule out there.
Right.
Because that was the Chiarello case. That was the one place where everybody had been saying Section 14E of the Securities Exchange Act gives the SEC power with respect to insider trade, to tender offer fraud that it didn't have elsewhere. So that was the path of least resistance. At that point, all work now is getting an agreement among everybody on how Rule 14E3 would read.
Right. So I have a bunch of follow-up questions here. So May 1980, the commission then has these 3 anti-fraud rules promulgated under the commission's rulemaking authority under Section 10b of the Exchange Act. Does the commission issue a decision or any written memorialization of its rejection?
No.
So it's memories like this that
Right.
allow us to
Right.
reconstruct the
Right.
events.
Yes, and again, you will get this story in the oral histories for both Dick Rowe and John Huber. John Huber was the person in Corp Fin with primary responsibility for putting pen to paper and getting a 14E3 out there.
And I want to talk more then about the Rule 14E3 ending, which does get adopted, I believe in September 1980, by the Commission. Just to pause a little bit on the broader anti-fraud provision that would have, you said, 3 subsections of sorts. One would be traditional insiders. A second would be fraud on the source of the misappropriated information. Right. And then the third was fraud on the contemporaneous traders in situations where information had been misappropriated or wrongfully obtained.
Yes.
And I'm struck, if we fast forward 40 years, the Senate now has before it a bill amending the federal securities laws that passed the House overwhelmingly in December, I believe 410 to 13.
Yes.
And so tell us a little bit about that legislation and the symmetry between that and the rule that we're percolating around the commission.
Right. Let me back up and add some texture to the story, because I had said before 2 things happened that involved me. One is I was the one who wrote the original 10bx that everybody then throws a hatchet at, and we have competing. But then Ralph and the team was absolutely convinced we had to grab hold of the litigation going forward as quickly as possible, because there were many cases percolating around, Dirks being one of them, where the Chiarello holding changed everything and was going to have to be rethought. So I was put on a train up to New York City because there was a case that ultimately becomes United States versus Newman. At the time, Jacques Courtois was the visible defended, and they were about to indict him.
A Morgan Stanley investment banker, former
Morgan Stanley investment banker.
Mm-hmm.
So raising these same issues about you get a secret from the bank you work for, you buy stock in some other company,
Right.
thus breaking the Chiarello fiduciary nexus. And Ralph and Paul Gonson very much wanted the U.S. Attorney's Office to plead as broadly as possible to preserve the alternative misappropriation theories. And I was an abject failure in the sense that the U.S. Attorney's Office very much was enamored with the fraud on the source theory.
Okay.
And in retrospect, I came to realize that's because they were infatuated with mail-and wire fraud, which at the time was using an honest services view of when you're entrusted and you deceptively abuse that trust, you commit mail-and wire fraud.
Mm-hmm.
Well, this was just that idea put into 10b-5. They knew it. They knew how to try cases on that. So I went home having, reviewed the indictment, and yes, it got fraud on the source right, but not with what we were hoping was a count 2 that would have put in play Chief Justice Berger's idea of a fraud on the marketplace arising from something akin to an embezzlement.
The duty to disclose to the target shareholders on the other side of the Newman trading. That's so the indictment in that case against Newman was filed, I believe, in February 1981.
Right.
And so let's go a little deeper then into your train ride up to New York and your involvement. So at the time, I think Lee Richards was the...
He was...
And so did you work with Lee Richards? Okay.
Yeah, that's who I went up to deal with.
Okay.
He and his team, and they were very polite and they understood. But criminal prosecutors always want to sharpen their case rather than let policy drive a wish list. They know what it means to be in front of a jury, and multiple counts and multiple theories tend to confuse. So I understand why they did what they did.
Right.
But it was the last real opportunity to get formal charges using a Chief Justice Berger approach. Ultimately, when subsequent cases like United States versus Carpenter come along, echoes of Chief Justice Berger can be found in them, but it's fading. And as you and I both know, because we've written extensively about this, sadly, I think, the connection to that duty to disclose based on the wrongful acquisition disappears in time. Later in the 80s, the American Bar Association charges Harvey Pitt and again a team of eminences to draft an insider trading statute. They use wrongful obtaining, one of those echoes, to craft a definition of insider trading, but ultimately politics intervenes and we don't get legislation beyond remedial legislation, the Second Sanctions Act.
Right.
So when we come today to the legislation that passed the House in December 2019, you're seeing a word that you may not trade while in possession of information that has been wrongfully obtained, where wrongfully is then defined to include breaches of fiduciary duty, but also theft, hacking, various ways that somebody through wrongful action. You're seeing that in And in many ways, it is a direct line from all of those decisions that were made in March, April, and May.
Of 1980.
Of 1980.
Yes, that's, I guess a principal difference is that when it's an SEC rule promulgated under Rule 10b-5, it needs to be tied to fraud.
Yes, right.
And
Here,
is that the case with the new statute?
no, of course
Okay.
not.
Okay.
In the sense that Congress can do what it wants, and many people have said, actually, insider trading isn't necessarily fraudulent so much as it's a market abuse. It should be illegal. There are very good reasons for it to be illegal. But the deception of contemporaneous traders may not be the best of those reasons.
Yeah.
Congress, in this case, could be stepping in and saying a more coherent basis for insider trading, and frankly one recognized around the world, is to simply say it is illegal to exploit this kind of information because it threatens the integrity of our capital markets.
And as you say, as most countries with developed securities markets have done to explicitly define the offense and prohibit it.
Exactly.
Interesting. So on the United States versus Newman case, so it's Lee Richards is the assistant U.S. attorney who prosecutes. There's a motion to dismiss the indictment granted, but then appealed to the Second Circuit.
Right.
Then he goes and he tries the case and he obtains the convictions there under a fraud, under a clear fraud
Yes,
on
right.
the source.
Absolutely.
Theory. And then we see the fraud on the source theory become the misappropriation
Gradually
theory.
become the misappropriation theory. Again, when I go back and look at United States versus Newman, United States versus Carpenter, Musella, there were a number of cases being decided at the time. When they talk about misappropriation, they're remarkably unclear as to exactly what the misappropriation is. It's like somebody's trying to preserve a little bit of that connection, but in the end, when you watch insider trading law ripen over the late 80s into the 1990s, the Berger misappropriation theory makes its disappearance.
Other than that attempt to broaden the indictment in U.S. versus Newman and the strategic decision of sticking with what the mail-in wire fraud, but now in a Rule 10b-5 deception of the source context. Were you aware of efforts on the part of enforcement at the SEC to bring civil cases that would allow the fraud to not only be against the target, not only to be against the investment banks or the printers or the law firms, but the contemporaneous traders?
There was a case brought against Crown Zellerbach. I remember because I wrote a memo to the commission.
Crown
Zellerbach. That was the commission's first real opportunity to address misappropriation. And if I recall, very carefully preserved multiple theories, just as Paul Gonson and Ralph Ferrara very much wanted. But United States versus Newman is the first Court of Appeals decision, and in the Second Circuit. So that was a signal that, okay, use that. They're both about misappropriation. It's not like you're giving up immense territory. But in fact, some things were given up by going in the direction of fraud on the source that would have been preserved had the alternative theory somehow not drowned.
So many more questions to ask on that, but I won't because I want to move. So I want to close out the Rule 14E3 story because the broader insider trading rule under Rule 10b-5 Commission in May of 1980 says no, work on tender offer, eradicate that problem. Rule 14E3 then is what it had already been proposed but it had
gotten so much
weathered
inside the building as well as outside
Right,
the building
okay.
pushback. It took Chiarello to create the momentum and get the
to get it to the finish line.
Get it to the finish line.
And that was September of 1980 then.
Right.
And then we have the sort of litigation front then in 81 in the winter time. But at this point, you're looking to move into teaching for
by
sure.
this time I had
you
accepted a
started there.
job.
Okay.
Yes.
And so before I start talking about your incredible career as a law school professor, inspirational career as a law school professor, is there any aspect of your time at the commission memorable that I've not managed to touch on?
Not really. I mean, this is the core part of it. I do, and I've suggested this obliquely, so let me say it directly. The people I worked with at the SEC from 1978 to 81 were intellectually the most fascinating, challenging people imaginable. Bob Posen, brilliant guy, my immediate boss. Ralph, one of the most creative lawyers who's ever gotten to run the General Counsel's office. Paul Gonson, a king. Jake's, and go on and on. I tried to do a list of who is famous, who was at the General Counsel's office at the time, and then who was famous now, was at the commission at the time. It's a long list.
Yeah.
So that sense of, wow, and now I'm going to be a law professor talking about securities regulation. It was the perfect, what now would be fellowship.
Yes.
But
Right.
fellowship on steroids.
Yeah. Well, and it replicated you being at Harvard Law School with Professor
Yes.
Louis Lawson
Right.
working on the Federal Securities Code. And
Right.
then
And he and Bob Posen are the ones who helped me get my first teaching job.
Yeah.
So they happily send me, I still have the letter Louis Loss wrote me congratulating me on getting my first teaching job. So,
that must be very touching,
Yes,
for
yeah.
sure. You say in one of your many books that one of the SEC commissioners, Irv Pollock, became one of your heroes
Yes.
and still is. And
Oh,
so
absolutely.
before we leave the commission
Sure.
2 years, I'd like to hear why.
And it's a little bit connected to what I was saying. I remember my first day at the SEC, which is never a pleasant day because you're filling out paperwork for the most part and you don't know what you're doing and you're getting lost in the building and all of that. An orientation for all new staff members. Turns out Mark Steinberg started the same day I did at the SEC. He's now a well-known law professor, an insider trading expert.
Yes.
And so we went in orientation, which was pretty much run by the enforcement division. They were the most visible and inspirational. And they brought in Commissioner Pollock, Irv Pollock, who had been the first director of the Division of Enforcement at the SEC, to speak to everybody. And he was truly inspirational. He talked not about making securities regulation better, but that public service is an obligation for all of us, and learning to allow our conscience and our honor to go to work in doing the tasks of securities regulation was how we should think about it. And so I was impressed that day. It so happens that my roommate in Washington was his nephew. So I had separately been able to say hello to him and just mention the connection, and he knew. So we knew each other. The one thing I remember about Irv, besides that incredible orientation talk, was much of the commission's business is very routine and done seriatim, where you march from commissioner's office to commissioner's office saying, we need your signature. And usually it's you go in, somebody senior to you actually says what needs to be said. You just sit there and smile. You get the signature and you leave. Irv would always find the most junior person on the team and ask, what do you think? And the conversation would go on with the junior people, because he said later, that's where the spirit, the heart of the commission is. It's staff, and it's not the big egos running the division. It's the people who show up for work every day like he did over the course of a career as a securities regulator.
That's what a lovely story. I can see why it had such an impact.
Yeah.
Well, so let's talk about law teaching, which is a
Okay.
subject that I know a little bit about too. So you've said that when you went to the Securities and Exchange Commission in 1978, you did that knowing that you wanted
Yeah.
to be a law professor and enjoyed the academic side of the practice that you were doing, and so you got your wish, and
Yes.
Vanderbilt Law School is
Yes.
where your first teaching position was. So in your long and distinguished career at Vanderbilt and then at Georgetown, you've participated in the hiring of, I would think, dozens of junior faculty members. How would you compare today's new hires in corporate and securities law to your cohorts 40 years ago?
Oh.
To you and
Major changes.
Yes.
The competitiveness of the market for teaching today is far greater than it was when I went. People of my age always say, I'm glad I went into teaching when I did, because I couldn't get a job in today's environment. Yeah, the empirical study, the theoretical study of securities law was emerging in the 70s and 80s. People, like Frank Easterbrook, were starting to conceptualize the field, but it still was doctrinal. It still was old-fashioned law. And I clearly got my job based on what I had written in that Cornell Law Review article, which was very doctrinal. It was very much about what constitutional law should look like in addressing the federalism problems associated with state tender offer regulation. Today, nobody comes into teaching without 4 or 5 publications, probably spent 2 years just preparing that record.
Sure.
And thus, the empirical and theoretical sophistication is just far greater than it ever was.
It was in 1978. It would have been pretty extraordinary for a new hire to have published in the Cornell Law Review.
Yes.
So you were.
Yes, I was very lucky, and I always
sure.
thanked Louis Loss for
Yeah.
steering me in the direction of writing a paper that was publishable.
Yeah.
Because Vanderbilt was surprised that I already had something in print, and I had already, by that time, I was already working on my Chiarello article.
Okay.
Because I had enough time,
Material-
free,
right,
and a lot of
and a lot of
material.
material to draw from.
So I call it, a post-Chiarello restatement, because I was working on the post-Chiarello restatement of the law inside the building.
Yes, and that was then
Yeah.
your first
So-
official law professor.
So that
article.
went into print after I got to Vanderbilt, what was actually written before my first day there.
Yeah. Well, that's a nice way of tying your
Yes.
practical experience and your academic interest together. And of course, that was one of dozens of insider trading related articles that you've written in your career as an academic. And I want to explore your just amazing productivity and impact of your scholarship. Before we do that, though, I want to talk just a little bit about teaching and your approach to teaching securities regulation, because presumably that is one of the courses you taught at Vanderbilt.
Eventually.
Eventually,
But
okay.
yes, actually, it's somewhat of a funny story. When I ended my interview day at Vanderbilt, and I presented myself as a securities person. I'm coming from the SEC. Here are my 2 articles. They mentioned, but we already have somebody who teaches securities regulation.
And who would that?
Larry Soderquist.
Larry Soderquist. Okay.
And I said, that's interesting. But we really need a contracts professor. So would you be willing to teach contracts? And I said, okay, but I'm going to be writing about securities regulation. It would be nice if I could teach it as well. And so that was left for future agreement, because Vanderbilt was a small school, and frankly, it didn't need 2 sections. And Larry was a very successful,
Yes.
had a case book. So, it's not like I could pitch a fit. I could go elsewhere, but I liked Vanderbilt. So at that point, I said, how about corporate finance? Because Vic Brudney had taught me corporate finance, and it was a stealth securities regulation course, and I figured I could do the same thing. So it turned out that I was teaching contracts and corporate finance at that point. Couple years later, I got a call from Harvard Law School because Louis Loss had finally gone to emeritus status, and he wanted me to teach securities regulation at Harvard. And I agreed to a visit. It turns out I never told Harvard this, but I had never taught securities regulation in my life. And I was being brought in specifically for the purpose of being what turns out to be the 3rd person after Louis Loss to ever teach securities regulation at Harvard Law School.
Okay. It's quite the test.
Yes, right. I just didn't
atmosphere.
mention.
Okay.
This is the first
Excellent.
time for me.
Eventually, then you do go
Eventually,
on to teaching securities
Larry
regulation.
and I agreed that it would be right. Because I think I had now an article in the Harvard Law Review about securities regulation. It might be appropriate for me to.
Right.
So we took the 2 basic securities statutes, and Larry said, "I like 33 Act," and I said, "I like 34 Act. Why don't we just split securities regulation in half into 2 separate 2-credit courses? Suggest to students that they take both, and do that sequence." And there was my toehold.
Right.
And eventually I bargained into actually teaching securities regulation.
Well, and then you are the co-author of one of the leading securities regulation case books with James Cox at Duke and Robert Hillman at UC Davis. It's a fabulous case book for securities
Thank
regulation.
you.
I say that as a happy consumer. I've
Yes.
taught out of it for 25 years. My students very much like its problem-oriented approach, which at the time was new for securities regulation books.
Yes.
That's and so our time is running short. So I spend an hour and a half on 2 years at the commission, and fast forward a 40-year incredibly distinguished teaching career. Can't possibly do it justice. Can't possibly discuss the breadth of your scholarship, the impact of your scholarship. So I will ask about your interest in psychology and behavioral economics, how that developed, where in your teaching career did your scholarship go in that direction?
Yeah, and as in all things in my life, there are connections back to the time at the SEC. By the late 1970s, and this is Frank Easterbrook's work, Ralph Winter and others, the notion of the rational actor model for how financial markets work had taken hold, and it was growing fast. And I had studied some of that in law school, some of the earliest courses built around the economic analysis of law I took. Clearly it was affecting corporate legal scholarship by the late 70s. So I was steeped in it. And I remember one day sitting in the commission room watching a debate about some issue. I have no idea what the issue was. And I remember saying to myself, what's driving the outcome of this conversation is not rationality. It's ego. And I ultimately wrote it, a series of articles about self-deception, about ego, and to this day I am convinced that I had it right in that commission room, that if you want to predict human behavior, you got to go well beyond a utilitarian calculus of expected return. So that was a note to self that ultimately got me working on this project, but much more directly. And some of this came out of the Code Project. The idea that you should integrate the 33 and 34 Acts, because when a company is widely enough traded, its market is efficient, and you need far less mandatory disclosure, or at least access to mandatory disclosure in an efficient market than you would with respect to IPOs or some other, was becoming an article of faith. In fact, there was a law review article, I forget who wrote it, and probably just as well as that I forgot, that said, we don't even need 10b-5 much because the market is smart enough to see through fraud. And, you know, my reaction was, that's not right. And I discovered very quickly that there was a contrarian literature, literally on contrarian investing, that was emerging, that was a counterattack on all of this, that lawyers and regulators were just paying no attention to. So I decided to write my first big articles once I was in academia on why we should be a little less quick to embrace market efficiency in all of these settings in which efficient markets are invoked. So as I read more about the contrarian literature, what I was discovering is that on every other page there would be reference to the work in social psychology on rational choice and not so rational choice, what we now know as the Kahneman and Tversky paradigms of heuristics and biases, was coming to fascinate game theorists and others. So if that had something to say as powerfully as people are reading, this must have something to say about securities regulation as well. So I started reading the social psychology, not just the contrarian economics.
Right.
And that produced a very progressive research agenda that lasted for 25 years.
Yes, and one, no doubt, that caught Georgetown Law School's interest, and you moved from Vanderbilt to Georgetown where you
right.
are now.
Yeah.
So my last question, I would love to hear more about. I could go through each of the law review articles asking questions, but so your government service ended in 1981 when you began teaching. But you've done much public service throughout your 40-year career in teaching, testifying in Congress, advising the development of legislation, service on the FINRA's National Adjudicatory Council. Can we conclude with reflecting on public service and the role of how being a law professor allows you to continue what was a small, time-wise, official full-time public service at the Securities and Exchange Commission?
And for this, I must go immediately back to Irv Pollock. Yeah, the words he used at that orientation speech about this is always, your career is always about public service, no matter where you are, stuck with me. So, you know, sometimes you just get invitations to speak, and, you know, very quickly, as I was working on social psychology, I became interested in ethics. And as I became interested in ethics, I became interested in the psychology of ethics. And that has turned out to be a very resonant body of public service work that I do. I talk a lot, I've done this at the SEC, at FINRA, for many organizations, about how we deceive ourselves into thinking that what we are doing is good and valuable when it's really just a cover for what we want. That goes back a little bit to that moment in the commission room when I said it's ego going on here, not rational choice. So I have tried to use all of these vehicles on FINRA's National Adjudicatory Council. I have since, actually, when I was at Vanderbilt, I would regularly go over to the SEC informally to do brown bag lunches for staff people. Just, whatever I can do to help make people think better about securities law, which is on multiple levels. It's not just the intellectual, analytical, empirical. It's about, making sure what we do really does serve others, instead of being a pretext for hypocrisy.
Well, I can't think of a better way to conclude this interview. So thank you so much. It's been a true honor to be here with you this morning. And
thank you.
Thank you.